Manhattan prosecutors are working through millions of pages of former President Trump's tax and financial documents after a Supreme Court ruling last week forced them to be turned over. New York County's district attorney is investigating wide disparities in valuations for Mr. Trump's properties. It's one of 3 criminal investigations, along with 9 more civil cases the former president is facing. That's according to the NYU Law School publication, Just Security. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins me now with more. Hi there, Jessica. Good to see you. So, a former U.S. president has never been indicted. Do you see any sort of charges as likely out of this New York case?
It's possible. I mean, at this point, we're reading tea leaves, and I hate to give you kind of it depends in terms of an answer, but they now have about 1 million pages in documents, and it really depends on what's in those documents. We know what they're specifically looking at. They're very likely looking at issues of tax fraud, fraud with respect to obtaining loans, and fraud with respect to maybe obtaining mortgages. And so what we're wondering is, did the president and his businesses, for instance, say, you know what, the value of this particular piece of property is really high when they wanted to take out a loan on the property, but then say, you know what, the value of that property actually is really low when they were talking about how much taxes to pay on that particular property. And so if he was committing fraud with respect to valuation, I think that would be one of the main areas where we could see an indictment. You asked me, will we see an indictment? And the answer is, I really don't know at this point.
So those are the areas you said where you see the most legal exposure. I wonder, though, Jessica, in a case like this, is it possible that you would have an outside sort of assessor making those kinds of valuations, which would then prevent some kind of charge being leveled against you successfully because you relied on a third party to make that valuation of that property, whatever it is?
Absolutely. So there's a couple of things that I think could help President Trump's defense in this case. One is that there are different standards for valuation. So if you're going to get a piece of property appraised and you had 3 professionals appraising that property, I think you could easily see 3 different values that are pretty different from each other. And that doesn't necessarily mean there's fraud. It just means that an appraiser has a good deal of discretion. The other thing, as you point out, President Trump is not the one who's actually doing this appraising. So what you would have to do is tie him to some sort of affirmation, tie him to the idea that he said, I looked at this appraisal and yes, I'm signing off on this either under penalty of perjury or in an effort to, again, get a loan, get a mortgage, or as part of his tax returns or other financial documents, such that you could show that he had that criminal intent. So as your question points out, you need to be able to point to the activities of that outside person, the appraiser, and try and make that connection and say, President Trump, knowingly and willfully, that likely will be the standard, understood that they were committing fraud in this case. And so the more he can say, look, I didn't know what was happening over there, that's just somebody else who has a lot of discretion, the better it is for him.
Jessica, I also want to ask you about Supreme Court arguments on a pair of voting rights cases out of Arizona. Now, one deals with restrictions on certain third parties who collect and deliver ballots for voters. Critics call that ballot harvesting, but another restriction penalizes voters who cast ballots in the wrong precinct. What is at stake here, considering it's been nearly 8 years after the High Court cut out the key part of the Voting Rights Act?
Yeah, what's at stake here is a lot, not just for the voters of Arizona, but what's at stake here is for all of us to determine what is the standard we use when we're trying to figure out if there is a violation of the Voting Rights Act. As you said, the Voting Rights Act passed in 1965, landmark piece of civil rights legislation, I think by all measures, very, very effective. And it really had 2 pillars. It had this one pillar called Section 5, and that said, if you're a state or locality with a history of discrimination, you have to check in with the federal government before you make a change to your election practices or procedures. If you want to change where your polling place is, if you want to change what your ballot looks like, you have to get the federal government's permission first because we're not really sure if we trust you. That was the part of the Voting Rights Act that the court essentially struck down in 2013 in Shelby County. Now, fast forward to today, we really only have that other pillar left. It's called Section 2. And under Section 2, individual plaintiffs themselves have to sue and say, you know what, whatever change, whatever practice or procedure you tried to implement, state or locality, that has a discriminatory effect. And so the Arizona case is important, not just because there's a lot at stake for people who are in Arizona, but because the Supreme Court could say, here's the standard we use when we're evaluating these types of cases. Now, we basically know the standard we use when it comes to something called gerrymandering, drawing district lines that might have the effect of something called vote dilution, making your vote less powerful. But we don't necessarily know the standard we use in this situation. And you talked about the Arizona law, where ballots are thrown out. If you go on election day and you try and vote provisionally outside of your precinct, your entire ballot would be trashed, including all of the races that are federal and statewide that have nothing to do with which precinct you're in. So we could see a really significant law being changed, and we'll know what the force and effect of the voting rights is going forward, probably as a result of this case.
And, you know, the makeup of the Supreme Court here, we should note with the 6-3 conservative majority, what's your sense here for a likely outcome?
So this is a more conservative court than the court that essentially eviscerated Section 5 back in 2013, again in Shelby County. So if we think of these issues as essentially being determined by how conservative or liberal the court is, then what we would estimate would happen is that the court would say it's going to be a very, very difficult test to satisfy. If you're an individual plaintiff and you want to say you were discriminated against with respect to your ability to vote, you're going to have to satisfy a really high threshold. The other thing we could potentially see from this Supreme Court is trying to find a safety valve where they don't have to answer this big question, but maybe they look at something like standing. Did the right person actually appeal this case? And that would allow them, I think, to kind of calm things down. Again, we're just coming out of an election year. We're just coming out of a very heated confirmation hearing with respect to Justice Amy Coney Barrett. So I think either we're going to see a test that's difficult for plaintiffs to determine, or we're going to see the Supreme Court say, you know what, let's take a cooling off period. There's some sort of procedural defect with this case. Come back to us another time when it's less politically charged.
All right, CBS News legal contributor Jessica Levinson helping us read the legal tea leaves. Thank you very much, Jessica.
Thank you.